Mr. Smith, you appear before this committee today not as a neutral observer of the law, but at one point you were one of the most powerful prosecutors in the federal system, armed with enormous discretion, minimal oversight, and a mandate that goes to the very heart of our constitutional order. You brought charges during an active election cycle. You relied on legal theories that had never before been tested in context. And you did so while disregarding long-standing Department of Justice policies designed to prevent prosecutors from influencing elections. Mr. Smith, you claimed in your investigation you developed proof beyond a reasonable doubt that President Trump engaged in criminal scheme to overturn the results in the 2020 election and to prevent lawful transfer of power. However, a few weeks ago in Georgia, Fulton County election board officials stated that 315,000 ballots were certified without required signatures on the tabulator tapes for poll workers. These signatures were required by the Georgia statute. If not counted, this could have turned the state of Georgia red, and I won't doubt there were similar schemes in many other states. You were illegally appointed to serve as special counsel since you were not confirmed by advance and consent Senate and stated in the Appointments Clause. You also issued an indictment against then-President Biden's most formidable political opponent. The candidate was President Trump, and you issued a gag order for President Trump during a 2024 election cycle. This was a major violation of President Trump's First Amendment rights and a poor attempt to outright censor the leading political candidate. These actions were nothing short of election interference. 9 senators, including Senator Tuberville from my state of Alabama, and multiple Republican members of the House of Representatives had their phones subpoenaed, or their records subpoenaed. Some you seized their phones. Even then, Speaker of the House Kevin McCarthy, one of the highest-ranking Republicans in the country, had his phone records subpoenaed, all for political gain. These subpoenas clearly violated the Speech and Debate Clause. As John Keller of the DOJ's Public Integrity Section addressed this issue in an email dated May 17th of 2023, D.C. Circuit President stated that the Speech and Debate Clause, and the bar is this, bar on compelled disclosure is absolute. These instances are not only the tip of the iceberg about you and your team's flagrant disregard of the Constitution. Mr. Smith, your actions have changed and damaged confidence in our justice system. Today, this committee will determine whether that damage was a result of reckless judgment, political bias, or deliberate misuse of authority. And with that, Mr. Chairman, I'll yield you the balance of my time for questions.
I thank the gentleman for yielding. I want to go back to that email, if we could put that up, this email that Mr. Gill highlighted a few minutes ago. This is the justification from the Public Integrity section. If you look at the bottom, John Keller, Public Integrity section, for going and getting the phone records, toll records of members of Congress. And there's a couple things I want to highlight. That first highlighted area, there is some litigation risk. So they admit there's some concern here. And they send this to the copy to Jack Smith's team. And then you go down later, as Mr. Gill pointed out, the case law is clear. A legislator may intervene and oppose such use. So the risk is real. But here's the deal. There was really no risk because we weren't going to know. They weren't going to tell us. They made sure they didn't tell us because they went to the judge and got a gag order. And look at the last sentence. The last sentence. Low likelihood that any of the members listed below would be charged. So they're not going to know because we're not going to charge any of these guys. They didn't do anything wrong. And so therefore, the litigation risk should be minimal. They're not going to be charged. We're not going to go after them. The litigation risk is minimal. And it's minimal because, frankly, it's non-existent because they're not going to know. And we're going to make sure they don't know because we're not even going to tell the judge who we're getting the gag orders on. And yet, Mr. Smith thought that was A-okay. That was just fine. That was in the letter and the spirit of the Constitution. I find that hard to believe. And you know why? You know why everyone knows it's wrong? Because the Public Integrity section at the Justice Department has now changed its policy. You can't do this anymore. They've changed their policy. But it was okay for Jack Smith to do it because we got to get Trump. We got to get the president. That's what this was all about. Yield back to the gentleman from Alabama.
Thank you, Mr.